Hello, it's Debbie on Move or Improve with Debbie, and thanks for joining me today. I am continuing a three-part series on the LGBTQ retirees issues, and today we're going to talk about legal issues with Eva Juncker, who is principal at Paley Rothman law firm, and she is in the family law practice, and she is a member of its litigation group, and she focuses on all areas of family law, including divorce, juvenile law, custody, support, equitable distribution. But she also focuses on transgender issues and LGBTQ concerns. And so welcome to the show, Eva, and let's get started.
Hey, thanks for having me. Before we start, can I give a quick disclaimer?
Yes.
Just my comments are not intended as legal advice for any of your listeners. They're merely intended to raise some issues of concern for thought. And I would encourage anyone who has legal questions or concerns as a result of listening to this to find local competent counsel, which can be done by contacting any one of the larger national LGBTQ legal organizations. They routinely have lists of attorneys that practice LGBT elder law in your specific jurisdiction. And just a few of those would include SAGE, which stands for Services and Advocacy for Gay, Lesbian, Bisexual, and Transgender Elders, National Center for Lesbian Rights, National Senior Citizens Law Center, National Gay and Lesbian Task Force, Lambda Legal, or the National Center for Transgender Equality.
Thank you so much for mentioning all of those, Eva. There's good resources out there for people. So what are some of the legal challenges that retirees in the LGBT community face in retirement? I know we've talked about housing and aging solo, but what are some of the legal issues that you can talk about?
Sure. Research shows that there are three cornerstones to successful aging. And for each one of those three, there's an LGBTQ challenge as a result of the fact that our nation has only recently sort of advanced the rights of LGBT individuals. And so particularly with the individuals that are looking at aging and financial and retirement issues at this point in their life, they've led most of their life dealing with a whole host of discrimination. And so the first and sort of biggest issue is economic security. And so one of the issues that the LGBTQ community faces is a lifetime of discrimination and lack of legal and social recognition in the working field. That can include things like not having been hired historically because of their LGBTQ status over their lifetime, or not having been promoted because of their status over their lifetime, or even having been fired because of their LGBTQ status. So financial insecurity, I think, is one of the issues that's unique and important to address within the aging LGBTQ community.
Well, answer me one question. I believe I read something the other day saying that the Supreme Court is going to hear October 8th on, they're going to evaluate whether it's illegal or discriminatory to fire an LGBTQ from a job. Did I read that right?
That's an excellent point. My understanding is there are three large nationwide cases that are addressing that specific issue that are going up before the United States Supreme Court. And that's going to be dealing with exactly that, whether or not LGBTQ individuals have legal protections in the workplace from being fired. But one of the issues that's going to impact the aging community is their careers may already be over. And so the impact, if any, of a decision that's coming up may not help this particular community.
Good point.
And so,
yeah, good point.
So one of the things that these individuals and couples in particular face that are dealing with aging at this point in time is the financial insecurity. Plenty of the LGBTQ community that are aged and coupled are unmarried, and so as a result, things that standard couples might take for granted, like being able to access their spouse's Social Security retirement income based on the spouse's earning, if that was the higher earning spouse, their earning history might not be available to these couples. Some of those same issues are going to apply to LGBTQ couples, the older couples, in terms of being able to access Medicaid, pension retirement plans, comprehensive estate planning as a result is going to be critical to this particular community.
It sounds like they have a lot facing them still, even though they have been declared not mentally ill from the APA years ago. At least they got over that, but now they have other things that are going on in their lives that they have to deal with. What are some of the biggest issues that LGBTQ retirees face in finding care or providing care for their loved one? I know we talked in the housing section about where to live and what kind of options there are, but what do you want to add to that from a legal standpoint?
Sure. The second cornerstone of successful aging, research indicates, is an individual's social connections. And so how does that apply specifically to the aging LGBTQ community? Well, whereas most individuals would rely on family, relatives, extended family, oftentimes with the aging LGBT community, individuals were ostracized from their family and so had to create a chosen family of very close-knit friends and community that sort of gathered together and took care of one another. And so one of the issues that can impact the LGBTQ aging community is trying to figure out how to plan for care as they age. One's chosen family can't always take leave to care for one another if they don't qualify as a legally identified family, or there's no relationship recognition for chosen family. Your chosen family may be aging around the exact same time. So if your chosen family is a sort of a close-knit group of individuals who are all around the same age, you may have some issue making sure that you can all care for one another. One of the other issues with chosen family is we've seen plenty of cases where the facilities, retirement facilities or medical facilities that the aging LGBT community is in, will restrict visitors to only immediate family, which again, if it's a chosen family, may not meet those relationship recognition standards. Being able, something as simple as being able to care for your longtime partner or spouse if you're unmarried can be a challenge. And there are legal avenues to work around that, which is one of the things, I'd love to talk to. But failure to recognize these relationships, these chosen families, particularly maybe where one partner died prior to the marriage recognition, the Freedom to Marry Nationwide, which only happened as of 2015, all of those can create serious issues of concern to the LGBTQ aging community.
Well, what recommendations can you give that on preparing like a power of attorney or an advanced medical directive? Are most facilities going to recognize if someone who is a partner but not necessarily married has power of attorney for that person? Will they recognize that?
That's an excellent question. I would say that a comprehensive estate plan is important for everyone, but even more important for the aging LGBTQ community, because it gives us an opportunity to very specifically identify who we want making medical decisions for us if we're unable to make those decisions, how we want our estates handled, who we want managing our finances if we lose the ability to competently manage those. And so, the standard estate planning documents are a last will and testament. Some jurisdictions, it's helpful to have a trust, a living trust, not all. But I would say the two most important legal documents for the aging LGBTQ community are a durable general financial power of attorney and medical power of attorney. And let me just really briefly explain why those are important.
Yeah, go through those very carefully, because I think they're very important, and it helps to have that information in front of them in case they don't know what to do.
Sure. So a durable general financial power of attorney is a document that you work on with your attorney or with one of these national organizations that may direct you to a more local national organization or local organization that's familiar with the aging LGBTQ issues. But it's a legal power of attorney or document where you designate an individual, and often you designate an individual and potentially one or two successors to the extent that the individual you designate isn't able to serve or doesn't want to serve for whatever reason, to make financial decisions for you, either now or at some shifting point in time when you're not able to make those decisions. And so that can be incredibly helpful in terms of making sure that your finances are handled by somebody that you love and know and trust, and not some random individual that may or may not be appointed by a court. And so when you're planning for things like living in a retirement community or a medical housing community, having somebody who can assist you with those financial needs and having that be somebody that you've selected, going back to that issue of having it be somebody from your chosen family who is then going to be recognized by various entities is important. So are these documents recognized? Again, it's going to be state specific, but yes, this is routinely the set of documents that individuals use to protect the decisions that they want to make when there comes a time where they're not able to actually vocalize or articulate those decisions. The second document is the medical or healthcare power of attorney. And that one's critical because just like the financial power of attorney, the medical power of attorney designates the individual that you choose, often with one or two successors, to make important medical decisions for you in the event that you're not able to. It can also designate priority of visitation should you be in a medical facility. So one of the issues I addressed earlier was, can your chosen family come and visit you if you're in the hospital or medical facility? Well, if you have a healthcare power of attorney that designates that chosen individual and says, this is the person who is to be given priority in visiting me if I'm in ICU or unconscious, those need to be honored. And to the extent that they're not honored, you may well have a cause of action, or your power of attorney may well have a cause of action to enforce it to make sure that they can visit you and make those medical decisions for you.
So when you're looking, basically you're looking for an advocate who will think like you would want to be taught, be treated, but you're also asking that person now if you're, for example, if you go to the hospital and you do have a power of attorney and a medical directive, the person who is acting on your behalf would have to bring those papers with them to the hospital to prove that they are okay to enter in and make a judgment on how you should be treated. Is that how it goes?
Absolutely. And best practices are always to share that documentation with your medical providers in advance. Yeah. Right. The more that you make your medical team aware of these decisions and these individuals that you've selected, the less issue that person may have when they step in and potentially need to exercise those rights. The other thing you're going to want to make sure you do is that you have those really important discussions with the individuals that you designate so that they know what you would want to have happen, not necessarily what they would want to have happen. And one of the other things that you can often include in those are things like living wills and how much sort of palliative care would you want to have happen should something unfortunate arise during a medical procedure.
So it's a lot like what a heterosexual would do, except that you have to find someone who thinks like you do and has your best interests. And shouldn't you have, does it help? Maybe it doesn't. Does it help to have more than one person so that if someone is unable to stand in for you, you have a backup person ready in the wings who can step in and say, hey, I am her advocate and I will be representing her interests. Does that make sense in this case?
Absolutely. Absolutely. And that goes back to where I said you often have one individual that you'll designate and then one or two successors. Because if you're going to go through the very important work of creating this document, and these are, by the way, important documents, and it's important that a legal professional help you draw these up. Oftentimes hospitals will have them, but I would really encourage everybody to find a competent local attorney to help walk them through and tailor these to their specific needs, particularly for the aging LGBTQ community. Because one of the things that can happen, I mentioned earlier, these individuals may well have been ostracized from certain members of their family. And so one of the things that you may want to have in one of your medical powers of attorney is, look, this particular family member and this particular family member are not permitted to come in and visit me and make decisions. And my medical power of attorney is authorized to exclude that individual. And so, again, having those discussions with the individuals that you want to have making those decisions for you, talking with your medical professionals ahead of time about that are all critical to making sure that you get the care you deserve.
Absolutely. Has it ever happened, or I'm sure it probably has at some point, but has it ever happened where the LGBTQ retiree, for example, is hospitalized and they have appointed someone to act on their behalf, but then the family member finds out about it and tries to barge in and take over and they don't have authorization?
Oh, absolutely. Absolutely.